The next case on the call of the docket is agenda number 8, case number 125768, In re Julie M. versus Julie M. Mr. Davison.
Good morning, Your Honors. Counsel, may it please the Court, I'm Matthew Davison, staff attorney with the State of Illinois Guardianship and Advocacy Commission. We are here on behalf of Ms. Julie M. asking this Court to reverse the decisions below. Specifically, this case centers around the application of the Mental Health Code to the care Julie received at a local hospital in the fall of 2018. Julie had been receiving mental health care in and out of mental health centers leading up to this immediate hospitalization, including this very hospital only days before, for self-harm and mental health issues in general. So when she arrived again in mid-September of 2018 for a suicide attempt and self-harm, the facility again began to initiate treatment on the medical side and as well as the mental health side of things. For the purposes of the medical care, the treatment team began to initiate surgical oversight to attend to her healthcare issues, and her psychiatric team began to reinitiate her mental health treatment as well. This included various psychotropic medications, therapy appointments, meeting with staff psychiatrists and other mental health professionals, and the like. In fact, in the words of the hospital staff themselves at trial and at the later hearings, Julie's care at this hospital never was unrelated to her mental illness or her mental health concerns. It was always a mental health case.
Counsel, is an admission to the hospital the same as admission under Article 6 of the Mental Health Code?
Good morning, Justice Garment. I might ask you for more specifics on your question, but are you talking about an Article 6 admission by court order in support of those certificates?
Yeah, any kind of a court-ordered admission.
Sure.
Is it the same as basically admission under the Mental Health Code, the same as admission into the hospital?
This court pointed out in Andrew B., we don't focus so much as where the person's physical location is or where they are. We focus on their legal status, and that kind of firms up what their admission status is with their mental health care. So what you do is you look at the provider and the recipient, and you see which way are they tethered to the code, and that would define their admission. Are they a voluntary recipient of services? Are they informally receiving services? Or are they contesting services, and are they subject to involuntary treatment or involuntary confinement? So every admission and every type of mental health care administered by a facility in this sense should always be connected to a part of the code that helps define and crystallize that relationship. And that's what the admission is for. So that's why you don't see a distinction in the code between what an admittee is versus a recipient. There's just recipients. There's no definition of an admittee because there will always be that connection between how are they admitted? Are they at your hospital voluntarily? Are they there against their will or not? So there will always be that type of kind of mirroring with the code's admission statuses.
May I follow up on Justice Garment's question? These are terms of art, of course. In your view, when Julie was brought to the hospital suffering from serious medical crisis, as well of course, serious mental health crisis, and she was brought to the hospital where eventually she received, extensive surgery, et cetera, as well as mental health care. The Mental Health Act creates 3 types of admission as a term of art under the code: informal, voluntary, and involuntary, and then 2 types of involuntary admission. In your view, when by ambulance or however she was brought to the hospital, what was the type of admission that occurred under the Mental Health Act?
We don't know because the hospital didn't follow the code. To back up a little bit, the definition of treatment under the code is very broad. It includes just mere hospitalization in itself. So if someone's coming into the ER from a suicide attempt, that's a mental health admission, and we know we're going to have to render services pursuant to the code. What the hospital should have done, since they already knew Julie from days before, is to say, Julie, we're worried about you again. Would you mind enrolling as a voluntary recipient, or would you mind enrolling as an informal recipient? If Julie was objecting or non-responsive, the hospital's duty at that point is to pivot and file a petition with the local court saying, we have someone here, we're going to start administering treatment in the form of confinement, and we're going to justify our basis for detaining this young woman. What the hospital was doing here is a pre-Linda B sequential engagement with the court system, which is we're going to attend to her physical issues, and when it's on our dime, we're going to figure out when we're going to engage in the mental health court.
What is an informal admission under the statute?
What is an informal
What is
admission?
it?
It's something as non-intrusive and simple as the provider and the recipient agreeing to come aboard and enroll in mental health care on an informal basis. It is the least restrictive form of treatment. To give you an example, if you're going in for knee surgery, but you're otherwise also maintaining your mental health care and something else on the side that you wanted to maintain, what your provider at the hospital could do is just simply enroll you in the psychiatric care on an informal basis.
And why isn't that the same thing that's happening here?
It would have to be documented, first of all. And the other thing that would need to happen is if that recipient requested discharge, the provider has to honor that request. The provider does not have the ability, like under the other statutes, to say, well, we understand you want to leave, but we have rights too. And just because you want to leave, we can still go to court and keep you here. The informal admissions, Your Honor, are much quicker. I don't want to take my antidepressant while I'm here. They have to back off and disenroll you in the mental health care at that point. They can't kind of go seek those other legal remedies.
So, counsel, your argument is that in light of Linda B, anytime anyone is admitted to a hospital for any medical reason, and they are being prescribed some type of, psychiatric medication, then the documentation requirements are now on the hospitals.
That's my position, and I also think that's the position of the legislator and the courts as well, Your Honor. I think that's been the case since Linda B, when this court recognized, wait a second, people are getting mental health care in all sorts of locations. I mean, I can't sprain my pinky toe and go get it looked at or touched at without going through 5 to 8 pages of paperwork in that sense. All we're asking here is if someone's coming in and getting powerful psychotropic drugs put into them or cognitive behavioral therapy, yes, I would contend that the hospital should probably notate that and make sure they're keeping track of, is this person accepting it? Do they not want it? Because what ultimately happens is you get a situation like the trial court here where you have a trial judge saying, yeah, she doesn't want to be here, but I don't know if that means she's involuntarily. What's the difference between objecting and not wanting to be? You get into this weird morass of fact-finding we don't need because the mental health code says, hey, provider, you have to establish the status of the care. If she doesn't want it, we get that. Come to court and tell us about it. But then there's going to be oversight. There will be an attorney involved. There will be kind of strict construction to protect that person's liberty interest in that way. So to answer your question briefly, yes, you absolutely have to kind of adhere to the mental health code if you're rendering those services.
So your position is just showing up to the hospital triggers all these other requirements?
Not in every case. So Julie's at the really far end of the spectrum where it was an open and direct, obvious mental health admission from the get-go. Suicide attempt, really bad. We can go further up the spectrum with a hypothetical. Say someone down here on the street, it gets cold out, it's winter, frostbite occurs, they get brought in, they're attending to surgical needs, attending to the person, maybe they're homeless. 4 days into that hospitalization, the person starts spouting delusional content and they're worried. At that point, if the facility's diagnosing, if they're introducing psychiatry help, yes, absolutely, then that would come in. But I would not go running into the trial court and saying that homeless person's immediate admission that's when the clock started. That's not appropriate either. It just tracks with the type of care that's being rendered, but you always have to connect it to the code in some way. Julie's is more straightforward on the spectrum because she came in right away. They knew her. They knew she had mental health issues. And they got her treatment started right back. The least they could have done is go up to her and say, we can admit you as a voluntary recipient, but we don't know if they did that. I would direct the court to the eventual pleading that gets filed in early October. That's a pleading out of the emergency provision in the mental health code. That's the hospital saying, we have someone here, we need to detain them, we're worried about their safety. But when you scrutinize the content of the petition and those certificates that eventually surface, they're talking all the way back to her initial intake at the emergency room. This hospital staff knew it was always a mental health case, but they filed the pleading when it kind of was suitable and convenient after the resolution of the medical issues, which is inappropriate given our modern landscape and the mental health treatment.
Well, maybe she was receiving voluntary treatment up until that point.
That's right, and we don't know.
Right,
and
but under Linda B, the plain language of Linda B, the burden would then be on your client to show when this involuntariness started.
Here's the problem, and that's the rub of it. So when we get to the 90% of Linda B is great, 90% of the decision below is great. The problem is when we get to the burden of showing the person's status and whether they were engaged or not. I really think that overlooks a great population of our clients that struggle with significant symptoms of mental illness, catatonia, major depressive disorder, internal stimulations. And for the court to task the respondent or the recipient of proving up how badly they didn't want to be in a hospital, are we to counsel our clients to try to elope as much as they want, strike out against providers to show how much they don't want to be there? Certainly not. I think the right thing to do is just to simply follow the code. If the person doesn't want to be there, file the appropriate paperwork. They are appointed an attorney. There's court oversight to kind of get involved there. But absolutely, you kind of need to make sure you're adhering to the code to ensure that. But the problem with the burden is you get statements like the trial court here. What's the legal response to a judge that says, yes, she doesn't want to be here, but how does that mean she's involuntary? There's no comeback.
These terms, one thing that I keep going back to is we're not using these terms colloquially. We're not saying, I want to do this or I want to do that. These terms are being defined by the code. The code has real specific definitions for what is voluntary, what is involuntary. And so I think, don't we have to go back to how the code defines what is voluntary? There, the patient files an application. Well, obviously that didn't happen here, right? So it would not seem that this does not sound like a voluntary admission under the code. It doesn't fit that procedure.
No, and the petition itself would corroborate that, Your Honor, because if you look at page 1 of the pleading, the petitioner in this matter is given a bevy of reasons to establish their legal basis. One of the top ones we see a lot is, hey, this person was voluntarily here, and they want to leave, and we're not okay with that, so we're now establishing a legal basis by following that petition. That happens a lot. Someone's voluntarily, and they say, look, I just want to go home. I'm not on board with this anymore.
But they originally were admitted on their own request, their own application.
Yes, and the facility accepted
the
that.
voluntary admission is defined as when a patient presents and files a application to be admitted.
Almost. Essentially, the provider is in charge of those forms, provides them to the patients, and it's actually up to the provider ultimately to whether accepted or not. So providers still reserve the right to say, hey, we understand it seems like you want to be here. We have questions about your capacity or your ability to sign yourself in. So we're going to go ahead and petition in this way. This case does not recite any type of indication that Julie was voluntarily engaged in treatment and then said no thank you. This petition that surfaces in early October suddenly says, oh, we have an emergency at our hospital and we need to confine this person for up to 90 days. So when her attorney goes and says, well, wait a second, was she voluntarily here to begin with? It doesn't look that way, so I'm going to file a motion to dismiss it. They go into court to move to dismiss it, and the trial judge pulls up Linda B and says, well, show us how badly she didn't want to be here. Show it. And that is out of sequence with the mental health code, Justice Tice, which you're pointing out, very much so, because these are terms of art. We need to track what type of recipient status they have with their provider, and if they can't substantiate it, they're very much outside the
So
framework.
you agree that, you told me this is not, there are 3 types of admissions under the code. Informal, you said that's not what this is. You agree voluntary means by patient application. That's not what this is. And if neither one of those apply, then you're saying, therefore, every admission of someone into the hospital for both medical and mental treatment is, by definition of the code, an involuntary admission. Is that what you're saying?
No, not at all. I think the vast majority of those admissions will be informal, to be candid with you.
So is that what we're supposed to be looking at? Is this informal or is this involuntary? Is that what we should be looking at?
Well, are you asking about Julie's set of facts in general, or are you asking about people at the hospital as a general concept, whether they're likely to be informal or
I'm asking
involuntary?
about which section of the code applies.
In Julie's case, the section of the code that applies is the involuntary commitment standard. And
When she presented with her injuries.
Yes. And what you do is you then take that part of the code and you say, are there deadlines in this code? Are there time constraints? Yes, there are. Did the facility follow those time constraints? Absolutely not. Their petition should be dismissed.
And why is this different from an involuntary? Can you tell me that again? Or not involuntary, I don't mean that. Informal.
Informal admission is between the provider and the recipient, where the provider has no concerns about the person's capacity or their ability to engage in treatment. And it's also the provider is obligated at the patient's request to discharge them from care and services at their request. There would be no situation where a young woman with batteries in her stomach would present at the hospital from a suicide attempt and the provider would say, oh, you can be informal. We're not too stressed about your ability to kind of rationalize what's going on here. And in fact, if Julie somehow was informal, she would be allowed to leave and be discharged from those psychiatric services at a moment's notice. We know that's not the case because the provider eventually files a petition alleging that it's involuntary all along.
It appears that all the parties, even the amici, feel that the clarification of Linda B is necessary. What clarifications would you suggest?
Okay, so thank you, Chief Justice. So we're here for a refinement. I think others really want to take a sledgehammer here. The refinement we would have is Linda B said what it should say, which is we're out there seeking mental health in all sorts of non-traditional facilities in all sorts of ways. And if a provider is rendering services pursuant to the code, they're a mental health facility, and they're obligated to follow the requirements of the code. That full stop, full stop. Instead of this whole, you're obligated to follow, but oh, by the way, if you're unhappy with it, you then have to show how involuntary. That is where we're getting with this stuff. I think Linda B got us almost all the way with it, and I think it's just that one loose end that we need to tie up to say there's no burden on the recipients, because it inverts the code and puts it on the respondent with the illness and disability.
You referenced, when you're answering Chief Justice Burke about receiving services under the code. How do we know when that happens when she was admitted to the hospital?
In Julie's case, yes, because when you look at services, recipient is talking about who's getting treatment. And when you look at treatment under the code, hospitalization, medications, diagnoses, things like that. Julie's case is probably much clearer than Linda B and all the other ones you'll ever see because of the circumstances of her initial admission. The harder cases are when, you know, what I mentioned with the frostbite, or down in Texas, they had someone come in with like really low potassium levels. So like, oh, I think this is medical. Let's put them over on the medical floor. And then a week or two into that admission, it's like, oh, this is mental health. We better follow the code. Those are the murkier cases. This is much more straightforward because when you mention recipients, that includes hospitalizations and confinement and making sure they kind of get that person back to baseline, especially if they're engaging in self-harm and things like that.
What about patients that go in that are not able to communicate? In other words, they're very, very sick.
Yes, thank you for the question, Your Honor. So if a recipient is brought in and the provider can't secure their voluntary or uncomfortable with getting their voluntary, the provider's obligation, if they want to confine or render treatment, is to petition in the court and say, look, we can't establish whether this person's consenting or not. We want to respect their due process and their liberty and make sure they get an attorney. So they would have to file a petition for involuntary commitment if they can't ascertain that person's wishes or their desires to be there. And that, what you're bringing up is why the burden is so problematic for us, because there's a great amount of people out there living with disabilities that can't really articulate for themselves, or where you and I might object or resist to treatment, they might express that in a different way. So if we just trust providers to let us know that's not really how it's supposed to work, what we should do is task the providers with, if you're going to be engaging in these services, you're also going to be engaging in our laws and making sure you're explaining and memorializing. And by the way, this isn't just for the people living with disabilities benefit. This helps the hospitals, because if this person comes back 6 months later and says, that was false imprisonment, I'm suing you, that was inappropriate for holding me, the hospital can hold up the voluntary and say, you signed in. You know, you consented to being here. So this is good for everybody, this framework, making sure you're connecting to these admissions. The burden and not tasking people with the connections is creating the migraines that you're seeing here with this. So it would be an easy fix to Linda B if we kind of got rid of that portion of the opinion.
Is anyone that's receiving mental health treatment or taking any kind of mental health medication then assumed when they go into the hospital that it's a mental health admission?
Yes, so under Linda B, if the hospital continues that mental health treatment as they're hospitalized, you know, if they're getting other services, that hospital's putting on its mental health hospital hat. But the benefit of that situation you're probably describing is that sounds like it would just be an informal admission. And
so if a person breaks their leg, and they're taking psychotropic medication, obviously the facility's first concern, or should be, fixing the person's broken leg. but they're given a medication. But you're saying that beginning at day one, they should proceed under the code.
Right, but here's the great part about that. The code has this great thing about informal admissions. That's all that is in the code is informal. So a person will come in with a broken leg. They'd say, "Oh, we're coming around with your pill this morning. By the way, this can be informal because you're not really here for mental health treatment, but we do have to document because we're administering mental health care to you. We do want to make sure we kind of dot our I's and cross our T's with this. So you're always going to kind of ping that person to the code in some way."
Thank you.
Thank you.
Any more questions? Okay. Thank you, Mr. Davison.
Thank you, Chief Judge.
Mr. Huzak?
May it please the court, I'm Assistant Attorney General Richard Huzak, counsel for the people in this case, and I urge the court to affirm the circuit court's judgment, not just finding on the facts that respondent was a person properly classified as subject to involuntary admission, but also denying the motion to dismiss that invoked alleged violations of sections 3-604 and 3-610 of the Code of Procedure, Mental Health Code. Before launching into the detailed discussion of the language of those sections and the other relevant sections that are presented in this case, including section 3-202 that the respondent has relied upon for their argument that the burden should be shifted to the people to disprove an assertion in an affirmative defense that there was non-compliance with these sections. I want to emphasize that there are some very, very important issues at stake here, and they require careful analysis of the statutory text, because to the extent that that text leads to a proper interpretation of the policy choices made by the legislature, then those policy choices should be respected. And the starting point for that analysis is the language of the statute. And I have to say, I am surprised that in the opening brief and in the reply brief, there is no discussion of the language or quotation of the text or discussion of the meaning of section 3-604 or 3-610 at all. We have instead an overarching policy argument about what the court should do as if it were acting in a legislative capacity in deciding what is prudent policy to apply in these circumstances. And I have to say that that is a misguided project. The court's responsibility is not to substitute for the legislature. The court's responsibility is to honor the legislative choices made if the interpretation of the statute can be reasonably resolved. And I believe that is absolutely the case here with respect to these issues. So I do want to say that there are, apart from the careful textual analysis of these sections, there are two overarching themes that the respondent has made in this case where we fundamentally disagree. And those go to these questions of statutory interpretation that are before the court. First, they say that every involuntary detention and treatment of someone is an admission of a respondent pursuant to Article 6 within the meaning of Section 3-610 of the Code. We disagree, and I'll be glad to address that more fully in a minute. We think that that language, as this court said in the Andrew B. case, has a specific meaning. It is in the context of an Article 6 proceeding that is commenced with the completion of a petition for involuntary admission supported by a certificate corresponding with Sections 3601 and 3602 of Article 6. So our position is that the language admission of a respondent, that means that a petition has to be filed, pursuant to this Article 6 means a proceeding has commenced in accordance with Article 6. They're saying, oh no, forget that. That's not what matters at all. If there's any involuntary detention of anybody under the code, then that is an admission of a respondent pursuant to this article. And then if you don't comply with the requirement that there be an examination by a psychiatrist within 24 hours of that, then an involuntary petition is a nullity. That's not faithful to the code. It would require this court to overrule its decision in Andrew B., which explicitly followed the language of the code faithfully, gave it effect, and said it means what it says. I have to recognize that there is some tension with some of the broad language in Linda B. on this issue. There is some dissonance there. But Linda B. did not purport to overrule the Andrew B. case. And this is now an opportunity for the court to clarify what this language means. Now, yes, Andrew B. and Linda B. involved an interpretation of 3-611, not section 3-610. But they both have the same beginning trigger event to start the 24-hour clock. And that trigger event is an admission of a respondent pursuant to this Article 6, or in one case, an admission of a respondent under this Article 6. I think those are roughly equivalent. So we urge the court to reaffirm the Andrew B. decision that follows the language of that code section and does not treat an admission under the code, which is broader than what section 3-610 and 3-11 say, as being the same thing as an admission of a respondent pursuant to this article. The second major issue that I want to present is with respect to the respondent's argument, and many of the members of the court address questions to this, that all treatment in a hospital, which it's a licensed hospital, it qualifies as a mental health facility under Linda B. We're not here to challenge that. All mental health treatment by a hospital necessarily constitutes or requires an admission for mental health treatment under the code. We just couldn't disagree more. The final statement by opposing counsel in his opening argument was that the respondent here, Julie M., was not really here for mental health treatment. That's exactly right. She was there for emergency medical treatment. This was a general hospital that has no licensed psychiatry beds. So they're not licensed to be a place where somebody can stay for mental health treatment on an enduring basis. They're a general hospital dealing with somebody who needs surgery because she tried to commit suicide and swallowed batteries. They did everything by the book. They were allowed to give this woman treatment consistent with a code, consistent with a common law that says you can't treat people involuntarily or detain them involuntarily without their informed and consent with capacity, or that's a tort, and it's also generally a violation of the code. But here it wasn't an admission for mental health treatment, and that is the key. And that's relevant to the question about the burden of proof here, where they rely upon section 3-202, and that in turn refers back to the general prohibition in section 3-200 that says a person may be admitted for treatment of a mental illness on an inpatient basis in a mental health facility only in accordance with Chapter 3. We absolutely agree with that. But let's step back a minute.
So, counsel, you're saying admission isn't really defined, is it, in the code?
Unfortunately, there is no explicit admission of definition of admission, but I think we all have a general sense of what admission is. It's not treatment.
But you're saying there are at least two different meanings, admission to the facility and admission pursuant to the code.
No, what I would say is that admission for treatment of a mental illness is a phrase that's used in the court in section 3-200. And so if somebody is admitted for treatment of a mental illness, then that would be something that the hospital must comply with Chapter 3, that includes all forms of admission. But if somebody is admitted for a medical urgency and they are treated also for a mental illness, that's not an admission under Chapter 3. At some point, it may become an admission under Chapter 3. But in this case, our position is that that occurred only when Julie M. was done with her medical admission And Carle Hospital had to say, we can't keep this person here on a voluntary basis or on an informal basis. We're not a psychiatric hospital. She's not clinically suitable for that. We're not set up to do this on a long-term basis, but she needs mental health treatment. She needs admission for mental health treatment, and the only place that was suitable for that was in McFarland. So they did what the code requires. They began a proceeding for involuntary admission for mental health treatment after her medical admission expired. The argument was made that the code doesn't distinguish between treatment and admission. I would say that's absolutely wrong. The code clearly distinguishes between mental health treatment, between an admission and mental health treatment. It provides separate protections for treatment wherever that occurs and separate protections for admission in a mental health facility. There is a distinction between a recipient of services, and it doesn't use the term admittee, but it does use the phrase person admitted for mental health treatment. So to use the common example that I think some of the justices were alluding to, you break your leg, you need a hip replacement surgery, you're in traction with IV tubes coming out of you for a medical admission, and you say, hey, I need Xanax or Zoloft. Can you renew my prescription and administer one of those to me? And the hospital is supposed to say, oh, no, now we have to treat this as a mental health admission, not just treatment of your mental health admission. Here's the piece of paper. Do you consent to be admitted for treatment of mental illness? And the patient says, no, I just want my Zoloft. I just want my Xanax. Well, you have to sign this paper or we can't give you that mental health treatment. That's wrong. That's not what the code says. The code says there can be no involuntary mental health treatment wherever you are. But that doesn't mean that you have to be an admission. Now, the respondent retreats to the position of saying, well, everything can just be an informal thing. We'll just make a notation in the file. That doesn't work. The person has to agree to be admitted for treatment of a mental health illness. That doesn't apply to every circumstance in which somebody is in a hospital for medical care. The director of the facility has to agree that there's suitability there for such an admission. And the director could say, no, this is not an appropriate patient for admission for mental health treatment, which is a professional diagnosis that they have to make and a suitability determination. Finally, they have a right to immediate discharge. Discharge doesn't mean, as they say on page 5 of their reply brief, the cessation of services. It means physical release. Well, if you're in traction with IV tubes coming out of your arms, and you say, okay, well, I demand to be discharged, what are they going to do? Roll your gurney from the ICU out onto the street? That doesn't make any sense. But here's the bigger picture problem. The public policy argument that they have made assumes that the mental health code is both the source and the remedy for all of the protections of personal liability interests. That's not true. The Constitution, substantive due process, protects people's liberty interests, and the common law protects people's liberty interests. The mental health code reaffirms some of those protections, and it also creates a regulation of procedures for the recognized exceptions to those general principles. So historically, the law has recognized emergency treatment in limited circumstances, and the mental health code provides a safe harbor for doing so. So if a hospital doesn't comply with those safe harbor provisions, there is a protection, which is that if it's a tort, there's tort liability. And if it's in violation of the mental health code provisions, there's also potentially a cause of action under the mental health code for a violation of those provisions. But the remedy is not always permanent invalidation of an involuntary admission petition that's subsequently filed. Here, going back to section 3610, this is an issue that the court carefully addressed in Andrew B. They're saying any involuntary detention must be an Article 6 proceeding for admission, even if there's no petition filed. We disagree with that, but under their theory, once that's done, it's permanently incurable. And Andrew B. said no, and it reversed the appellate court on cases that said that once there is any involuntary detention, that's an admission of a respondent pursuant to this Article 6, and therefore you can't, cure it and start all over again and do it. under their theory, where every involuntary detention is an admission of a respondent under Article 6, you can't fix that problem. There's no way to cure it, and the remedy is permanent inability of the public to implement the public interest under the Mental Health Code of balancing the two interests between the liberty interests of people who are mentally ill or are alleged to be mentally ill and the public's interest in parents patriae interest in protecting those individuals and protecting the public at large. In this case, this is a no good deed goes unpunished theory by the respondents where they say, oh, well, the hospital, having tried to save this woman's life, provide her necessary mental health treatment in addition to that, and when she was no longer under a medical admission, began a proceeding to have her detained, and there's no evidence that she was ever involuntary for any of this stuff, but they couldn't keep her. The theory is that they had to put her out on the street where she was trying to commit suicide and was homeless. That makes no sense. I cannot imagine that the legislature, thinking of this situation, would have said that that's what they intended by the Mental Health Code. The first of the sections that they invoked, 3-604, again, is an Article 6 proceeding. It involves, I mean, if Article 6 is sort of like a preliminary injunction type thing, Article 3-604 refers to the TRO type thing, which is you can't even get, the certificate in support of the petition, and you have to detain the person for examination to get that certificate. And 3-604 says if you can't get that certificate within 24 hours, the person shall be released. It has nothing to do with this case, and there's no defense of why there was an alleged breach of the duty under that provision, how it applies at all. The tougher issue, obviously, is Section 3-610, and that's the one that has the similar trigger event as the court addressed in Andrew B. and the Linda B. case. And on that one, the court has to ask itself, what is the duty that it creates, and what is the consequence of noncompliance with that duty? And on the second issue, sort of with some foreshadowing here, we have urged the court under its authority to affirm the circuit court on any basis, and because this comes up under the mootness exception of questions of public importance, to clarify something that I think the appellate courts have not followed despite the court's teachings in James W. and Rita P. and the recent decision in the Lakewood nursing home cases, that there's a difference between the duty and noncompliance with the duty, the consequences of noncompliance. That's the difference between mandatory and directory. Respondent alludes to the Radishevsky case back to 1994, which unfortunately confused mandatory permissive and mandatory directory. And even in Robinson, the court said, unfortunately, it has contributed to the confusion. Nobody's infallible. Now's the time to sort of clarify, for the benefit of the appellate courts and lower courts generally, that every section of the Mental Health Code is subject to that mandatory versus directory analysis. A violation of it doesn't always, for every provision, automatically trigger the consequence of invalidating an involuntary admission proceeding. That's what the court held in James W. Directory, not mandatory. And there are obviously sections of the Mental Health Code that are mandatory. You fail to give the respondent a lawyer, you don't apply the clear and convincing standard of proof. I think we could agree that those are violations that nullify the proceeding and prevent entry of it. The burden of proof issue, I think, is adequately addressed in our briefs. I think that the Section 3-202 analysis is also addressed in our brief. We do want to reiterate that the public policy arguments used by the respondent to get the court to adopt its interpretations of these relevant provisions of the code are misplaced. They overlook the fact that there are other common law protections for some of these things. The code itself provides protections for some of these things. So it is not the case that somebody will be left without the protection of the code unless the court agrees with the remedy that they seek here in all these cases. So I see that my time is running short. I do want to emphasize the three most important things that we are asking the court to do here. It should not overrule Andrew B. and its interpretation of the triggering event under Section 3-610, which is the same as the triggering event under Section 3-611. And it should not hold that every involuntary detention by a hospital and provision of mental health treatment is an admission of a respondent pursuant to Article 6. Those are two different things. The involuntary detention may trigger all sorts of other legal consequences, but it does not fall within the meaning of that term as enacted by the legislature. Second, the court should not rule that all mental health treatment in a hospital requires an admission under Chapter 3. That forces people to be put into the situation of saying, yeah, I want to be admitted for treatment of mental illness, but that's not really why I'm here. I'm here to have my hip replaced, you know. And the code provides protection for that. The public policy argument that there's no protection unless you force an admission on these people, or you know, if they say, no, I don't want to be admitted, I just want my treatment, well, sorry, we're going to have to go to court to, you know, require that you be physically detained and involuntarily treated. That makes no sense. And the court should also clarify respectfully that for the reasons articulated in the People's Brief, that Sections 3-604 and 3-610 are directory, not mandatory. That doesn't limit at all the responsibility of the hospitals to comply with them. It just says that if in some circumstances there are non-compliance, that doesn't automatically prevent a court from protecting the public's interest and vindicating the health code interest in involuntary admissions. Thank you so much, Your Honors.
Thank you, Mr. Huzza. Mr. Davidson?
It is disheartening to hear the people of the state of Illinois suggesting that key bulwarks protecting fundamental liberty interests are merely suggestions and not mandatory. Those provisions carry strict remedies if doctors and petitioners don't file paperwork and attend to people in a timely manner. If you adopt their theory and their reasoning here, people can be detained ad infinitum until they decide, the hospital decides, okay, we've taken care of what we need to take care of. Now we'll get the courts involved. Now we'll get a lawyer involved. It's a bridge too far, and to embrace an idea that some of these provisions are merely directory is going to relegate key provisions of the mental health code from being promises to mere platitudes. It's also going to have the effect of not just applying to non-traditional providers, you're going to disrupt statewide mental health proceedings at state facilities too. Sorry, I'll put this on. So it is extremely troubling in that way. As counsel alluded to, if someone comes in and they want a Xanax with their thing, they don't have to be a voluntary admission and go through all the paperwork and all that. They can informally enroll in that care just as quickly as they can take themselves out of that care. But what's important is that it's memorialized in some fashion. No one has mentioned, the record is clear. There's a doctor saying 3 days into this emergency room visit, psychiatry was consulted again and inpatient psych was needed. Okay, if that's the case, where are the protections? Where is the involvement of the legal system? There wasn't one. And to the idea that there's other torts available and other remedies, I have to tell you, serving our clients and suggesting that they go find a lawyer to sue for false imprisonment and take 2 years to do all that rather than giving them 5 weeks of their life back when they were unlawfully detained at a facility, every day of the week they're going to take, please grant my motion to dismiss because they failed to comply with the code in that way. You know, Chief Justice McMorrow told a room full of her colleagues and some law students a few years ago, we have to remember the law above all else is about people and their problems. This case is about people and their problems. We have to ensure that when we're giving these people these services, whether it's just a prescription, whether it's just therapy, or it's all these things, we have to track with the mental health code. Because what you're going to have are situations when facilities then decide to petition people, and we go all the way back to their initial admission, and for weeks and weeks they were without counsel, they were without court oversight, and they were without any intervention until the hospital decided so. That is not the law. I really invite this court to take it. I certainly take issue the state's assertion on page 34 of their brief that says, in many cases, including this one, a person may be a recipient for treatment but not without being admitted. The lack of a citation on that assertion is deafening, because if you go back the near 50 years, the last time the governor assembled a commission to do these rewrites and these legislative updates, there is no suggestion for that theory. In the 50 years since that rewrite, there's been no appellate case ever saying such a thing. In fact, it wasn't until we got here at the 11th hour in this briefing that it's now being proposed. People can receive mental health treatment, but float freely from the code without any protections or safeguards. That's inappropriate. And we're not asking too much of the hospitals. It's a very simple process, and it's a very simple form of engagement. I understand that, as someone that geeks out and Monday through Friday gets mental health law, it's nuanced, it's overwhelming, it's in a little corner of the world. These are very clear protections that have never been interpreted that way.
Well, does it boil down to whether or not all mental health treatment in a hospital is necessarily an admission?
Pretty much.
And does Andrew B. speak to that?
Andrew B. speaks to the idea that someone can be in a facility, order discharge from services, but nonetheless not leave that facility and then be re-petitioned or resubmitted. Andrew B. was an unfortunate case where a facility petitioned someone to establish their detention. The state non-suited the case. The facility said, we're not letting him go, so they re-petitioned. This court said, first of all, the court said, that's very alarming, that a facility can do this to someone against their will. The legislator should get involved and do something. Legislator never did. So when we're operating out in the world under Andrew B. is just meant to say that someone's status can shift and change. But, Your Honor, all that means is that they can go from signing in as a voluntary, requesting discharge, being involuntary. They're just ping-ponging, but they're ping-ponging around the code still. So all Andrew B. So we're not asking to do any violence to those cases. We're really here just to clean up a portion of Linda B. But to go down that road is going to, it will really be a Pandora's box in the trial courts, to be candid with you. If the court has no further questions, I appreciate your questions, and thank you, and we would ask that you reverse the decisions below.
Thank you, Mr. Davidson. Case number 125768, in re Julie M. versus Julie M. Is taken under advisement as agenda number 8. Thank you, Mr. Davidson, and thank you, Mr. Huzek, for your arguments this afternoon.